Hello, everyone, and welcome to another online edition of Business Law 301. Today we're going to cover the material in the second half of Chapter 10. So let's begin right away.
Throughout the course, we've been suggesting that contracts can be evidenced by a verbal agreement as well as in writing. Well, now we're going to discuss at least 3 exceptions where for a contract to be legally binding, it must be put in writing. This comes to us from the Statute of Frauds. This is an old English law from hundreds of years ago, the purpose being that some contracts are quite important, and therefore for one party to enforce the contract against the other, they have to have written proof. The first exception we'll talk about is a guarantee for repayment of a debt. You might recall we talked about co-signing arrangements, where one party is going to guarantee the debt of another. That is a guarantee, and therefore for that contract to be considered legally binding, there must be some written evidence. Second, a sale of interest in land. There was a recent case where a real estate agent was punished for failing to put a real estate contract into writing. That is considered serious negligence by a real estate agent because they should know that for any sale of interest in land to be considered legally binding, it must be put to writing. Lastly, contracts that are not going to be performed within a 1-year period. This is perhaps an unusual type of contract to have, but let's say that you were going to mow my front lawn 13 months from now. In order for that contract to be considered legally binding, it must be put into writing because the services are going to be performed over a year from now. Now, these are the laws in Alberta and other jurisdictions that still have a statute of frauds. Some provinces in Canada have simply decided to get rid of this requirement, and therefore these types of contracts that we've just discussed can be legally binding even without evidence of writing. The question should be asked, what constitutes evidence of writing? Of course, having the essential elements written out on a document is one thing, but if this is a matter of an item being sold, things like price or a mechanism for determining price would be important. So ensuring that all the essential terms of the contract are included in the writing. Further, of course, a signature is the best way to show that both parties assented, assuming there's only 2 parties to an agreement. And finally, using witnesses or a notary is a best practice. A notary is an individual, typically a lawyer, but other individuals as well, who have a notary stamp, which when affixed to a contract is an assurance by the notary that the parties are who they say they are, the contract was executed on a certain date, and that the parties understood what the agreement entailed. Beyond the statute of frauds, other laws also speak to ensuring that contracts must be in writing. In most consumer protection legislation, they require that service providers put out their contracts in writing in order for them to be considered legally binding. This would include prepaid services where a party is paying in advance of the service being provided. In most provinces, those contracts must be evidence in writing. This could also include internet contracts and other matters of a consumer protection legislation. The next topic is mistake. This seems like an appealing argument. Imagine one party is selling what they think is a green car to a purchaser, and then when the contract is set to be finalized, the parties realize that the purchaser was thinking that a blue car was going to be sold, that those parties are potentially under a mistake. Well, as we're going to see, there's at least 2 forms of mistake. Mistake as to identities of the parties in the contract, and mistake as to subject matter. And as we're going to see, there's very limited mechanisms in order to try to cancel a contract based on the concept of mistake. Firstly, we'll talk about mistaken identity. Now, this might seem like a silly example, but imagine it's your responsibility to hire a clown for a children's birthday party. So you call up the clown agency, and it's your expectation that you're going to get the most popular clown in town, Bozo the Clown. But who picks up the phone at the clown agency? It's Eric the Clown. And Eric is very jealous of Bozo because Eric hasn't been getting any of the gigs to go out to kids' birthday parties. So when Eric picks up the phone, he doesn't misrepresent himself by pretending to be Bozo the Clown. But you, on the other end of the line, think you're speaking to Bozo. And you set up a contract with Eric to come out to this birthday party. Now, when Eric shows up, you say, hey, you're not the clown I thought you were. And Eric says, too bad, I didn't misrepresent myself. We made a contract. Here I am. Now you have to pay me. What do we have here? We have a mistake as to the parties of the contract. You thought you were getting Bozo the Clown. You ended up accidentally, by mistake, hiring Eric the Clown. This type of contract can only be canceled if you can show, like in my circumstances with Eric the Clown, that Eric knew that you were under a mistaken impression that he was in fact Bozo the Clown. And if Eric took advantage of that fact, that he knows you were under that impression, then you can cancel the contract. But it would be up to you to show that Eric was aware and it wasn't on his end, just by happenstance didn't realize that you were trying to hire a different clown. So if Eric doesn't have that intention and you can't prove that, you won't be able to cancel the contract based on mistake as to identity. What about mistake as to the existence of a subject matter? This goes back to my first example of saying the purchaser thinks they're buying a green car, but it ends up that they're buying a blue car. First of all, this is where we have to think clearly about what we've learned so far with contracts. Remember what it takes for a contract to be legally binding. We always look to the intention, offer and acceptance, which is a meeting of the minds, and consideration. Let's focus in on the concept of meeting of the minds, where there's an offer that's capable of being accepted, and it is in fact accepted, leading to both parties being essentially on the same page and understanding what the terms of the contract are. Another term for meeting of the minds, the Latin term is consensus aea. And you see it up here on the slide that if no agreement on subject, then no consensus. So let's think about this. Why would we argue mistake as to subject matter if a party believes they're buying a different car from the seller? And let's just presume that both parties are just genuinely of a mistake. They were thinking of different vehicles. Do we really have a meeting of the minds? Do we have consensus? And if that is the case, that we don't have a meeting of the minds, then there's no contract to begin with. So to circle back, the point here is that if you have a genuine mistake as to the subject matter of the contract, you likely wouldn't be arguing mistake to get out of the contract. You would be arguing that there was no contract in the first place because one of the essential elements, meeting of the minds, has not been made out. Now, let's imagine a different scenario where someone is selling a car and they haven't seen their car for a couple of years because it's a collector's item that's been sitting in a garage. They find a purchaser who's very interested in it. The parties execute an agreement. They come to a price and everything seems to be enforceable, but they show up to pick up the car. And it turns out that there'd been a fire where the car was being stored for several years and the car has been severely damaged and neither party was aware of this. That is potentially a mistake. But what if, using a different example, someone is selling their home. The home is in perfect condition, and the purchaser is expected to take possession and move in a few weeks. But then during that time, there's a fire that destroys the home. The difference here is that the subject matter of the contract was destroyed after the contract was created. And that is the concept of frustration that we will discuss next. Here's a real circumstance where I dealt with a matter of frustration. 3 students rented the second floor of a home while they were at school. On the first floor, there was a fire caused by another tenant. This didn't burn down the building, but the smoke damage was to such an extent that the students were told on the second floor by the fire department, "You can't live here. This is uninhabitable." Now, the landlord, who did not live in this home and had these tenants, obviously decided that it wasn't the fault of the tenants on the second floor. It was the fault of the tenants on the first floor. So the landlord's position with the tenants on the second floor was, and assumed that this fire happened, let's say, on November 15th in the middle of the month, that the tenants on the second floor would be let out of their lease agreement, which went for many months because it was a year-long lease. However, only at the end of November. Therefore, the money collected for rent for all of November was going to be kept by the landlord. Effectively, these tenants were going to be paying for 2 months of rent while they couldn't live in this apartment, and they thought that was unfair. So my position on their behalf was that this contract was frustrated. Why? Because what was the whole point of the contract? To have a place to live. Now, because of an intervening event caused by a third party, not the fault of anyone in that particular contract, the tenant or the landlord, the subject matter of the contract was effectively destroyed. They couldn't live there. And so for this reason, the contract came to an end as of the day of the fire on November 15th. So those tenants were entitled to the second half of the rent from November to be paid back to them. You might recall that we talked about a boilerplate clause in a contract called force majeure. This means an act of God. Point being that you should deal with issues that could give rise to frustration right in the contract itself. This could mean one party keeps insurance over the contract, or this could simply be that one party is responsible in the event that the contract is frustrated. Now, to be clear, the common law rule for frustration only applies if the subject matter of the contract is completely destroyed. So back to my example of the burned down home. Imagine the fire department said, you can't live here day to day, but the kitchen still looks fine and you can use the kitchen. Can the landlord take the position that you still get some benefit as the tenant out of this contract despite the fire? Under the common law rules, that would have been an acceptable argument, but today most provinces have overridden this rule and brought in legislation so that if a majority or a part of the subject matter has been destroyed, the other party can still receive compensation even though the entire subject matter hasn't been wiped away. Next is a concept called non est factum. So Latin term again, what does it translate into English? This is not my deed. So imagine someone is going to a bank to sign a loan agreement, and they have every intent to read the contract thoroughly, but they need reading glasses, and as they walk into the bank, they drop their reading glasses, stepping on them, therefore they won't be able to read the loan agreement before they sign it. What if they discover later on that the interest rate was much higher than they had anticipated? Can they argue, this is not my deed, non est factum? I'm going to say no. In that circumstance, non est factum wouldn't work. Why is that? For this rule to work, you would need a radical difference between what the party thinks they're signing and what they actually sign. In this case, it's still a loan agreement. With a higher interest rate, does that make it radically different in nature? No. So when would non est factum come into play? Imagine someone has what we call a prenuptial agreement. We discussed this earlier in class, where parties who are entering into marriage decide that they would like to have their assets not split 50-50 according to the ordinary rules of matrimonial property law. Well, in order to trick one party into signing the contract, what if one of them said, please sign here, it's flowers delivery. All we need is your signature. But the person ends up signing a prenuptial agreement when they thought they were just signing something to accept flowers. That would be a case where there's a radical difference between what the party thinks they sign and what they actually sign. Next is a concept of unfairness in bargaining power. Now, throughout the topic of contract law, we have said contract law can be fairly harsh. It doesn't matter if the contract's unfair. It's still enforceable if it has intention, offer, acceptance, and consideration. Well, we'll talk about at least 3 ways that someone may be able to escape liability under the contract because of something that strikes to the heart of the contract, which is deeply unfair. When you think of duress, think of a threat that's being made. Can you have offer, acceptance, and consideration in a contract where someone has a gun to someone's head and says, sign it or else? Well, of course you can. But did that person sign it of their own free will? No, they signed it because the person was threatening them. So threats can take the form of physical violence. They can also take the form of threats not against that particular individual, but someone close to them like a friend or a loved one. They could take the form of threats against the goods that the person owns, or in certain circumstances, they can be of an economic variety. What do we mean by economic duress? This is a circumstance where someone would say, I know that you need to sign this, else you're going to be in deep financial trouble, so I'm putting it to you as a threat that what choice do you have but to sign this contract? Now, is that always going to be an excuse to avoid liability under a contract? In fact, it's very rare for economic duress to actually allow a party to escape liability under a contract. The reason for that is all of these things need to be made out. That the threat is made in bad faith, that the victim could not reasonably resist, and that the victim acted promptly once pressured removed, and the victim didn't get legal advice before succumbing to the threat. So what does this mean? It means the ways to avoid potentially being accused of economic duress is to ensure that the person has either seeks their own independent advice or have them sign a waiver that says, I told you should go out and get your own independent legal advice, but you've decided to waive that suggestion. As well, the threat has to be made in bad faith. There's a difference between giving someone a very punitive, that means problematic for that person type of offer, such as here's a loan, but it's at a very high 30% interest rate. Well, is that made in bad faith? What if it's because the person has terrible credit and you'd be very concerned about giving them money and their inability to pay back unless you were being incentivized with a very high interest rate? That's not bad faith. That's just a business decision. Further, the suggestion that the victim has to act promptly once pressure is removed. This means within a couple of days after this alleged economic duress has occurred that the person tries to get out of the contract. They can't wait several months and then say, oh, I was under economic duress. So for all these reasons, it's very difficult for economic duress to be made out as a way of escaping liability under a contract. When you think of undue influence, think of pressure. This is a circumstance where one party is pressuring the other one into entering into a contract. Now, there's effectively two different forms of undue influence. The first is where there is a fiduciary relationship between the parties, and the second is without a fiduciary relationship. You may recall that we have discussed the concept of a fiduciary relationship. It's where one party has a unilateral obligation to act in the best interest of the other party. This happens in a physician-patient relationship, a lawyer-client relationship, a priest to someone who prays at their particular church. So in fiduciary relationships, what's the issue with undue influence? We just presume that the party with a fiduciary relationship has power and influence over that person, and the other person can't reasonably resist their power. So let me give an example. A doctor selling their beach home to one of their patients. Because they have a fiduciary relationship, and even though it's in the context of medical issues and selling a home is not a medical issue, the fiduciary relationship would still mean that we presume the doctor effectively took advantage of their patient in executing that contract. So this means that the patient can say, I don't want to buy your beach house anymore. We had a fiduciary relationship or you had this unilateral duty towards me, so I want out of the contract. Now, the doctor in that circumstance can overcome this presumption that they took advantage of their patient. The way they can do that is simply in the contract to have said, go out and get your own independent legal advice, or waive getting independent legal advice, or just showing that the transaction was in fact fair and the doctor didn't take advantage of the patient. Now, in situations where there is no fiduciary relationship, you can still show undue influence, but it becomes the burden of the party who's trying to prove undue influence that there was in fact this pressure. And because of the pressure, it influenced them in such a way that the bargaining process was flawed and unfair. So this would take some evidence, would take credibility to show that the other party did in fact apply such pressure that it took advantage of this particular person and effectively forced them into entering into the contract. Next, we'll talk about unconscionability in transactions. The test here is no fair-minded person would offer such an arrangement and no right-minded person would accept the offer. Think circumstances where the parties have capacity, but something diminishes their ability to bargain in their own best interests. Here's an actual case to demonstrate how unconscionability works. Mr. Bundy is an older gentleman, and he has a son who's not a very good son. In fact, his son has extensive gambling debts. Now, a loan shark is willing to lend money to the son, but only if Mr. Bundy agrees that if the son fails to pay back the loan, then Mr. Bundy has to give up the family farm that's been in his family for generations and generations. The loan shark shows up at Mr. Bundy's farm and asks Mr. Bundy to sign the agreement. Now, there wasn't economic duress, there wasn't undue influence, but it was an offer that, according to the judge in the Mr. Bundy case, no fair-minded person would offer that, because what's in it for poor old Mr. Bundy? Sure, his son gets a loan, but Mr. Bundy gets nothing. And no right-minded person would accept that, according to the judge. Mr. Bundy was older, he still had capacity, but it wasn't fair, and it didn't seem like something a right-minded person would accept. So for that reason, the judge said the transaction was unconscionable, Mr. Bundy got to cancel it, and there was no liability on Mr. Bundy's behalf, and he gets to live out his days in the family farm. Now, to be clear, unconscionability will only be used if it can be shown that there was an extreme unfairness in the bargaining process, and one party was clearly taken advantage of. A word to describe this is that the contract is improvident. There's an extreme inequality of bargaining power. There is ways to overcome an argument of unconscionability if you are trying to enforce a contract. For instance, like with economic duress and like with undue influence, suggest that the other party receive independent legal advice before you enter into a transaction with them. Some provinces have special laws to protect those who might be taken advantage of through unconscionability. This includes laws where there might be cooling off periods, that parties have certain time period to get out of a contract, disclosure requirements that parties have to come forward with material information, and also prohibiting the use of exclusion clauses in certain circumstances. Lastly, we'll talk about illegality. Now, if someone is trying to sell illegal drugs, contract falls through and they try to bring it to court to enforce that drug transaction, good luck, because contracts that are illegal in nature cannot be enforced for obvious reasons. But we have to think a bit beyond just criminal type of illegality. For instance, what if a sale of an industrial park is going through, but it turns out the purchaser did not get the appropriate environmental permits they need in place in order to finalize the transaction? Perhaps not criminally illegal, but technically that's against environmental regulations, and that contract would be seen as void and not binding. There's also rules in the common law where there's been judge-made rules to suggest that a contract is not binding. This also includes not where there is a particular rule that has been violated, but judges sometimes say this goes against public policy. A good example is when it comes to a will. Now, when someone is alive, they can give their property to whoever they want, for whatever reason. But in a will, things may be a bit different. So to be clear, a will is like a contract, but is a legally binding document to state that when someone is deceased, who inherits their property and who becomes the owner of it. Now, there's been will cases where, for instance, a child is receiving a substantial portion of what was left over in a will from a parent. But the parent has said, you only receive this gift if you're married, if you marry someone of a particular religion, if you have children by this age. That's been brought to court, and judges have declared those type of gifts out of a will to be against public policy. There's no particular rule against putting in those requirements, but judges have said, we're going to say that that particular part is carved out and that the gift can be given without the condition of being married or partnered with someone of a particular religion, because that portion of it, that requirement, is against so-called public policy. This also includes restraints on trade that can be against public policy. You may have had a job that required one of these conditions put into your contract, such as a non-competition clause. So imagine a contract where someone is hired as a hairdresser by a hair studio, and they're told by their employer, if you quit or even if you're fired, you can't work for another hair studio ever again or ever carry on a business as a hairdresser. That would clearly be against public policy. However, and these are very common, to have a clause in an employment contract to say you can't work at another salon within a certain 20-kilometer period for a 2-year period in the city of St. Albert, these all seem to be legitimate restraints on trade because they're limited in their time and in their geography.
And that's it for finishing material in Chapter 10. I'll see you back in class.